Hello, Dr. Bechtel here. I have a video, I'm doing this video lecture about adoption in Florida. It's very abbreviated adoption areas, and there are other channels that have some beautiful stuff about adoption, so I recommend you look there as well. Again, this is dealing with adoption in the state of Florida. So we're not going to be venturing into other areas, other states, for example. So, getting started, my little laser pointer. So it's obvious what adoption is. It's a process by which a person can become the legal parent of a child. And it changes lives for the better. People who are under stress, maybe unplanned, unmanageable parenthood, is the problem that they're encountering, a parent is encountering, and bringing fulfillment to the lives of adoptive parents. There are a lot of beautiful stories about, in the media about the life-changing aspects of adopting children and being an adoptive parent. And it can provide a stable and loving home to a child who otherwise might know only poverty and neglect. But an adoption, a badly done adoption, by contrast, can be heartbreaking. And this heartbreak will affect, obviously, the prospective adoptive parents, and an innocent child could be wrenched away from the only parents they've ever known, possibly the only safe place. So it's a public policy consideration when looking at areas such as adoption law. The public policy needs to respect existing parental rights. The policies need to ensure that children are only adopted into suitable homes. And the adoption policies need to provide finality and stability for the child. And the process itself will expose vulnerabilities of both the birth parents and prospective adoptive parents, so it's necessary to protect them from exploitation. Two main categories of adoptions. Category 1, and this is the most common adoption. These are by non-relatives, where a mother has voluntarily given a child for adoption. Category 2 originates in dependency proceedings, when a dependency court determines that reunification with the child's natural parents is not appropriate. The next best result for the child is to be adopted. As such, there are different starting points with two kinds of adoption, but they follow essentially the same process. Adoption agency is the agency that shepherds the adoption through the process. They do the investigating, and they investigate the prospective adoptive parents before preliminary placement. And the second type is there needs to be termination of parental rights, and that needs to be accomplished in a separate proceeding before the petition for adoption can be filed. One focus important for paralegals and other legal professionals working in the family law office is there are step-parent adoptions. And these are relatively low risk in terms of what the policy is about. So their procedures and the protections afforded, they're more relaxed. A home study is not required, and an adoption agency is not required either. And there's no separate proceeding for termination of parental rights before filing a petition for adoption. And that would be step-parent adoptions. Non-relative adoptions, where we have participants, this is the second type of adoption, or the most common type of adoption, is where the participants include the prospective adoptive parents, the child that's going to be adopted, the child's birth mother and father, and then an adoption entity or intermediary. And this is basically the adoption agency. And it's an agency licensed under Florida statutes. They're a child-caring agency registered under Florida statutes. And there's an attorney intermediary or the State Department of Children and Families. So any one of these four types of adoption entities work as the adoption agency, if you will. So they're agencies and child caring agencies, an attorney intermediary, or State Department of Children and Families. Special considerations are involved in non-relative adoptions. An adoption entity, that would be from the last slide, if I were to replace that word agency with entity, that might be a better word to use, since agencies are also one of those entities. So adoption entities identify children who are or may become available for adoption. We also have to keep in mind, in serious public policy, that baby selling is illegal, and as a result, that being a potential third-degree felony, care needs to be taken as far as the policies concerning what can be paid to the birth mother, and that would include reasonable living expenses for pregnancy and up to 6 weeks postpartum expenses. It requires extensive documentation of the expenses, and that documentation is submitted to the court for approval after the process is complete if the expenses exceed $5,000. So if it's less than $5,000, there is no court approval required. Adoptions prior to termination of parental rights, there must be a designation that the placement is at risk, and because the child may need to be returned if the parental rights are not successfully terminated. And again, taking into public policy the concerns that there are, that people involved in the process can be vulnerable. So Florida statutes, Chapter 63, is where you find the law of adoptions in Florida. First, the child must be available for adoption, and any existing parental rights have been terminated. This means consent of mother, express or implied consent of the father, which can also result from inaction or abandonment by the father. Child whose parents have had their parental rights terminated under Chapter 39, which is a different chapter, is available for adoption. Physical possession of the child is delivered to the adoption entity, and then preliminary placement with prospective adoptive parents with a favorable preliminary home study. And then the adoption entity reports the preliminary placement to the court, and the court commissions a follow-up study. Then the adoption entity or the prospective adopted parent files a petition for adoption. There are legal complexities involved in adoption. First, we have constitutionally protected parental rights. The birth parents have constitutionally protected parental rights. Step-parent adoption, however, does not terminate parental rights. And mothers acquire, and public and policy says that if you're the mother of a child, you've given birth to a child, you've acquired your full parental rights by giving birth. Biological fathers, they have limited rights unless they can attain legal father status, and that is handled under Chapter 5 of the Florida statutes, paternity specifically. The father would then contribute genetic material by the biological father. It does not compare to months of pregnancy and hours of labor and delivery. So that's just sort of contribution of genetic material versus biological father. Mother who goes through hours of labor and delivery. Not me. I did it quick. An unmarried biological father, formerly we called this putative father, and you still will hear that term in the news and other places. But an unmarried biological father is entitled to a reasonable opportunity to develop a relationship with the child and attain full parental rights. And the result is an adoption will almost always require the consent of birth mom, but will generally not require the consent of birth father, who, after having knowledge of the child, does not act as an actual father. So I find that quite interesting. The petition for adoption, which is outlined in Florida Statutes, Chapter 63.1 and 2. It's signed and verified by the petitioner. It's filed with the clerk of the court. It includes information like the date and place of birth of the person to be adopted, the name to be given to the person, the date the petitioner acquired custody of the minor, and the name of the entity placing the minor, if there was one, the full name, age, and place and duration of the residence of the petitioner, and the marital status of the petitioner, a statement of the petitioner that the petitioner is able to provide for the material needs of the child, a description and estimate of the value of any property of the person to be adopted. The case style, of course, is included on the petition, and the reason why the petitioner desires to adopt. Other documentation that goes with the petition. One is a certified copy of the court judgment terminating parental rights. That would have happened under Chapter 39 or under Chapter 63. If the adoptee is an adult or minor relative of or stepchild, so that's important, of the petitioner, the required consent goes along with it, unless it's excused by the court. The favorable preliminary home study of the department, or licensed child, one of those entities that was on the previous slide, that are qualified pursuant to Chapter 63.092 of the Florida Statutes. They will do that preliminary study as to the suitability of the home the minor has been placed, and unless the petitioner is a step-parent or a relative. And a copy of any declaratory statement previously entered by the court pursuant to Chapter 63.102. And documentation includes also that an interview was held with the minor, if older than 12 years of age, unless the court, in the best interest of the minor, dispenses of the minor's consent. Consent. When is consent required? Well, consent may be waived if the child is deserted or abandoned. By inaction, there is a waiver of consent. Equivalent of consent is a petition for termination of parental rights, and that would go through a service of process. If there's no response after 20 days, the court has to hear a party who appear. If there's no response after 20 days, there's a waiver. But the court, if someone does come to the hearing, even if they have not filed a response, the court must hear, even if the answer was not, must hear that party, even if the answer was not filed. When consent is refused. So when consent is refused, you must have this proof that the birth parent has abandoned the child if consent is affirmatively refused. So the abandonment is how you get past the consent. Neglect or abuse versus abandoned. It's best to file dependency action under neglect or abuse situations under Chapter 39, and that would obtain a termination of parental rights in that proceeding. And so special rules of adoption are going to apply under those neglect or abuse situations. And again, keeping in mind, might be dealing with one or two chapters of the Florida Statutes, Chapter 39 and Chapter 63. When non-relatives adopt, the adoption entity plays a central role in the adoption process. and the extensive disclosures to the birth mother to obtain her consent, to commission a licensed social worker to do the preliminary study of the home and prospective parents. Must conduct a final home study, sorry I have a typo there, before the final judgment of adoption can be entered. So this kind of repeats what we talked about earlier, but I like to separate things out so you can look at both ways this would work, because there are two types, and we're also talking about step-parent adoption in this lecture. The finality of an adoption. So there's semi-strong protection. A consent document is binding and effective upon execution, and it can be revoked within 3 business days if the child is over 6 months at the time. So semi-strong. Absent revocation, consent can only be set aside if it's shown that it was induced, the consent was induced by fraud or duress. Once a final judgment is entered, it can be attacked only by showing that it substantially failed to meet the requirements of Chapter 63 of the Florida statutes. And the judgment can't be challenged at all after 1 year. So semi-soft, got a couple of conditions, revocation is possible, depending on the age of the child, 6 months or older, so it can be revoked within 3 days, and then 3 business days, and then if it's induced by fraud or duress, and then if it doesn't meet the requirements of Chapter 63, that's another. That's why we read in one of the first slides. That's why a poorly done adoption can really wreak havoc on the situation, and this type of thing could happen. But after 1 year, it can't be challenged, and there's no court cases to date that apply to that. Now, where did I get this information? Well, it's on this references slide, the last slide of this lecture. This is an excellent writing essay. Basically, it's a secondary source from the Florida Bar. They have some outstanding family practice materials. This I get from Westlaw. If you don't have Westlaw, you might go to your library. Typically, the courts have a law library and have access to Westlaw for the public. So if you have Westlaw through a school account or work account, you can get right to this article or to this secondary source. Like I said, it's outstanding. And if you don't have it available to you, go to your local law library, see if they do, or even call your public libraries. They may have it as well. So thank you very much for your time today.